Be upstanding for the court. All persons having anything to do before the Honorable, the judges of the Court of Appeals, draw near and give your attendance, for the court is now in session. God save the people of South Carolina and this court.
Good morning. Please be seated. Thank you. Madam Clerk, if you'll please call our case.
Case number 2022-001587, 315 Corley CW LLC v. Palmetto Bluff Development.
Ms. Austin.
Thank you, Your Honors. May it please the court. My name is Alexandra Austin. I, together with my colleagues that are listed in the briefing, represent the defendants in this case, who are the appellants in this appeal. This appeal involves the denial of a motion to compel arbitration. The plaintiffs in this case are all property owners in Palmetto Bluff. They include individuals, LLCs, and a trust. All owners in the Palmetto Bluff community agree to be Palmetto Bluff club members when they purchase their property, and all of the plaintiffs are club members.
How did they agree to do that?
They agree to do that based on the governing club documents. They contain provisions that incorporate, that set a community governance for the community, and upon accepting a deed, they become a member. They become a member of the club, and they agree to be bound by the club documents.
Did they sign to be members, or they were initiated automatically in some fashion?
They do. They agree to sign a membership agreement.
Which they did?
Which they did, and the vast majority of plaintiffs did.
So not all plaintiffs. There are certain non-signatories, right?
There are certain non-signatories.
Okay. Let me ask you about this. I was just curious about this. Speaking of the community charter, on record page 215, 216, for whatever it's worth, there's language that says if the parties do not settle a claim within 30 days after submission of the matter to mediation, the claimant shall thereafter be entitled to file suit, the operative phrase, file suit, or initiate administrative proceedings. Does that come into play in any way in this matter, or what's the import of that language?
Yeah, it does not, because the mandatory arbitration provisions contained in the membership plan and in the membership agreements, which were signed by the majority of the plaintiffs, are the more specific contract. The club documents govern club disputes. The charter is much broader. The club is only referenced in one of 20 of the chapters. It covers a much wider variety of disputes. For instance, trust property, things that have nothing to do with this case. And so the community charter specifically carved out, by virtue of the club documents, a specific subset of claims which should be referred to mandatory arbitration.
And my colleagues, please feel free to jump in. I don't want to squeeze you out of any questions that you have, so we'll take as much time as we need. There was a provision added on June 19, 2007 that says that the provisions of arbitration apply to those who became members after this date. That's correct. Is that correct?
I believe 2017.
Yeah, that's what I said. June 19, 2017 is what I intended to say.
Correct. That's correct, Your Honor. Okay.
So did any of the homeowners in this suit become members after that specific date?
Three did, Your Honor. One is an LLC. However, that LLC has a signed purchase and sale agreement which contains a binding arbitration clause. And then there are two individual plaintiffs. And that really gets down to the root of the issue, that although there are a lot of parties here, the vast majority have signed arbitration agreements. There are three that really are at issue. And it is this one LLC that does have another signed arbitration agreement that would cover the dispute, and two individuals who, as club members, are despite not having a signed membership agreement, they are nonetheless subject to the club documents, which include the membership plan, which also contains a binding arbitration clause, and also can be bound through recognized principles of equitable estoppel.
So there are only 3 non-signatories in this instance of the 21 or so that we're...
That is correct.
Okay. I want you to respond to this, and I apologize for reading this quote, but the Fourth Circuit Court of Appeals stated that while parties may agree to have an arbitrator decide gateway questions of arbitrability, such an agreement does not preclude a court from deciding that a party never made an agreement to arbitrate any issue. That is, it does not erase the court's obligation to determine whether a contract was formed. Thus, the incorporation of rules of AAA which allow the arbitrator to rule on questions of arbitrability does not obviate the need for courts to decide the threshold issue of contract formation. What's before us? Is it a question of contract formation, or is it a question of the validity of the agreement, arbitration agreement that's before us?
The existence of the agreements are not in dispute. So I do not believe that it is an issue of contract formation. It is as to the scope of the agreements, and the plaintiffs allege that they are unconscionable, so as to the unconscionability, and whether or not these 3 non-signatory plaintiffs can be bound by principles of equitable estoppel.
Unconscionability doesn't go to contract formation in your view?
No, Your Honor, because the issue with unconscionability is supposed to be limited to the arbitration provision itself, not to the contract as a whole. So those issues should have been referred to the arbitrator pursuant to the delegation clause.
Do you have a case that you think is your best case on that? It's fine if you don't. It's not necessarily a hostile question. I just want to...
Judge Hewitt never asks hostile questions, so I want to declare that for the record.
There's a few, Your Honor, regarding delegation. There's the Henry Schein case and Rent-A-Center case.
Okay.
Importantly...
Well, how is this different than the Smith versus D.R. Horton cases where a homeowner buys into something and has no choice about the matters? And in those cases, we were looking at whether the contract even existed. How is this different than that?
This is very distinguishable from those cases because of the sophistication of these parties. There is abundant evidence in the record of the very sophisticated nature of these parties. They own businesses, many of them are in real estate specifically, this is a second home. This is a luxury purchase. It is not a necessity of life, such as a car or a phone.
But isn't that something that a court needs to make a determination about? I mean, that's certainly what the case law seems to say. Simpson says that the court has to make the decision about that. How do you distinguish Simpson in this situation?
The court did recognize that evidence had been presented of sophistication. Ultimately, it determined that sophistication wasn't relevant. However, it is. Under the unconscionability analysis, it's specifically an element that should be considered and that the court should have considered. And it did acknowledge the existence, and that was unrefuted evidence. It just, in our opinion, incorrectly held that the sophistication of the parties should not matter.
Well, so I guess what I'm trying to get at, and I'm not doing it very artfully, I apologize, but there are certain things that have to be demonstrated to show that there's an unconscionable contract, correct?
Correct.
And in order for those things to be analyzed, there has to be a body that is analyzing that, whether it's arbitration or whether it's a court. And Simpson says, as I read Simpson and the statute 1548-20 says, it's got to be the court.
The basis on which the court found that it was unconscionable was that it was a contract of adhesion, which the case law says is in and of itself is not sufficient without more, and that there were certain statutory remedies and a statute of limitations that purported to alter what otherwise might be available. And the law says that when there is a delegation clause where these issues were intended to be referred to arbitration, which here there is a delegation clause delegating all of these issues, the existence, the scope of the arbitration agreement.
But that seems to be contrary to what Simpson and what the Fourth Circuit said in Rowland.
The case law is that where my understanding of case law is that where it's unclear how an arbitrator would handle issues like a statutory remedy, that the proper route is for it to go to arbitration and see what the arbitrator does. And here, there's also, the community charter contains a savings clause, so to the extent that something is inconsistent with South Carolina law, it should not be upheld. By incorporating the commercial arbitration rules, it ensures the fairness of the process by the arbitrator. And the case that I'm referring to is the AT&T case, which holds that in cases where it's uncertain how the arbitrator will construe remedial limitations, the proper course is to compel arbitration.
How does it impact the outcome of this case that the record, that the agreement has language that there should be no treble damages? And I think that's on record page 376, but in the U.S. Supreme Court case that dealt with that. Do you have any comments on that as far as unconscionability?
To the extent that, so again, the arbitrator, in light of the delegation clause, in light of the scope of the delegation clause and the clear intent to delegate those issues to the arbitrator, those issues should go to the arbitrator. If the arbitrator imposes remedial limitations, then the court has the ability to hear those claims. But there is, as the court, I think, itself recognized, there was no indication that the plaintiffs here would in any way have their remedies limited, because it was not clear what the court would do. What the arbitrator would do. But
I'm saying that language is in the contract, right? I mean, is that not void in and of itself, or void ab initio, or whatever other Latin phrase you want to use?
Certainly to the extent, if there is a claim that could not be referred to the arbitrator, then certainly all other claims which do not impose remedial limitations should be referred. Here, I believe that involves one claim. They allege that there's remedial limitations with respect to their Unfair Trade Practices Act claim and declaratory judgment, but I have not seen any law, nor have the plaintiffs presented any law, that a declaratory judgment cannot be referred to arbitration. So here I think we're only referring to the Unfair Trade Practices Act claim. So to the extent that if it was referred to the arbitrator and the arbitrator construed it in a way that violated South Carolina law, then the court would be able to hear that claim. To the extent that there were concerns about its impact on whether or not that claim could be referred to arbitration, then all other claims should be referred to arbitration, and with the exception of that claim.
Anything else for Ms. Austin?
And the clear intent to delegate these threshold issues comes from the reference in the arbitration agreement to Rule 7 of the AAA or something like that?
Correct, Rule 7 of the AAA commercial arbitration.
That's what I went looking for. It's probably somewhere, I can find it. I'm going to ask you where it is. I can find it. Thank you. Sorry.
Thank you. We'll hear you on reply.
Thank you, Your Honors.
Mr. Ford?
Good morning, Your Honors. Ian Ford here on behalf of the respondent homeowners, and I'm here with my colleague, Anthony Tillman. This is an important case for thousands of South Carolina property owners who own property in planned communities. As Your Honors knows, there is a lot of planned communities in South Carolina. The number's growing. The case has a lot of complexity, but at its heart, this case is about what restrictions a developer can bind to land in South Carolina, and whether there are any limits on what a developer can bind to real property, to South Carolina land. And do they have to follow the law like the rest of us have to follow the law? And that includes about matters as important to South Carolina citizens as access to the courts and to trial by jury. This is not just about a developer stuffing terms into thousands of pages of documents. This is about whether a developer can deprive property owners of the right to access to the courts, even when they do not have those terms in the governing documents, even when they do not have an arbitration clause that is signed by all of the defendants and plaintiffs. That's what the trial court considered and properly rejected, and that's what this court is considering today. Here, the developer is trying to force 21 plaintiffs to arbitrate with 12 defendants, and that's despite numerous undisputed facts. Those undisputed facts include that 21 of the plaintiffs and 11 of the defendants have no written arbitration agreement whatsoever. It's an undisputed fact that the one defendant with an arguable arbitration agreement, the club, has no such written agreement with 14 of the plaintiffs.
So do you disagree with Ms. Austin that there are only 3 non-signatories?
Absolutely.
Who this would be subject to, may not, or at least arguably not be subject to the agreement?
Yeah, I think she might have misspoken on that. I'm not going to speak for her, but there are a lot of non-signatories.
But there are 3 that predate the magic date
That's what I
that
think
it
she
appeared.
meant.
And then the dispute is over whether the people bound the LLC and the trust and this, that, and the other. But there are 3. The 3 comes from before the magic date.
Exactly.
You don't dispute, though, do you, that a significant component of this dispute is, I was trying not to use the word dispute twice in the same sentence, and I did it. You concede that a significant component of this dispute is a disagreement over the club practices and the club plan for the Palmetto Bluff Club, right? Your clients are seeking to more favorable terms from the governance of the Palmetto Bluff Club and access to amenities, right?
I don't want to say dispute because it sounds a little harsh, but we don't agree with that characterization.
They're changing the rules in a way that affects your client's ability to utilize short-term rentals without the preferred vendor, right?
I respectfully disagree with that characterization. This is why.
Okay.
What this case is about, at its heart, is whether the developer can impose unlawful restrictions on real property, such as, here's an example, and I think I'm getting to your question now.
Okay.
One of the things they impose when you accept a deed is that you, as a property holder, have to start paying money to their separate LLC that is a for-profit entity. And we say,
And you say that's illegal, and you cite the North Carolina case and say that this revocable license, and that's the bad language. If it was an easement, it would be different, right? That's what that case says. I mean, I'm oversimplifying.
Okay.
But what I'm not articulating, I appreciate the answer. I'm having trouble figuring out like what bucket to put this case in, because it seems like your cross appeal is this automatic membership by virtue of a deed, by acceptance of a deed, we become bound irretrievably to membership in this club that's a for-profit entity, and that violates the statute and it's not enforceable. And then another component of the case seems to be they're changing the amenity access in a way that interferes with our short-term rentals. We would like membership agreement to be enforceable, but on more favorable terms. And I'm having difficulty understanding how those relate to each other, because it seems like if you're trying to exact more favorable terms from the development and access to its amenities, that direct benefits estoppel, it's like the poster child case for that.
I'll take that in 2 parts. First, what I think is your first part of the question, then the estoppel.
And I really apologize for putting it so poorly, but
No, you're doing great. I hear it, and it's a complex case,
Yeah.
and it is, and y'all are taking it fast, and again, we have a short time to talk about it. the heart of this case, and I keep saying it, what bucket to put it in. This is a real property case. This is a real property. What encumbrances can a developer impose on land in South Carolina? And all these things you've identified are symptoms of that bigger problem. What my clients have the core problem with is the encumbrances that they're placing on their property when they take, and what's a symptom of it? A symptom of it is a separate for-profit club that apparently the developer claims it can change the rules at any time. That's a symptom of it. But if it were just about the club, and we wanted, I don't know, to change the pool rules or something at the club, we wouldn't have to have all the other defendants in it. But we do, and it's because it's not just about the club. It's about the unlawful structure that the developer has imposed on this community. And all of these things flow from it. So we talk about the club, we talk about the trust, which is the HOA. We talk about the hotel that they're trying to funnel money to. That is a product of the unlawful structure of the entire community. So I understand, the tactic on my opponent's side, which is let's make it all about the one thing that has an arbitration clause. But that is a minor part of this bigger scheme where the main document for the analysis, in my view, is to look at the contracted issue, and that's the community charter. The community charter is the constitution, for lack of a better word, of this community. When you take a deed, you purportedly have accepted the community charter. And that community charter gives everything else in all the other documents their life and power to the extent they have it. So let's look at the community charter. It allows filing suit in a court. Now, what do? They tack on this minor agreement later that's not of record, the membership agreement and so on, and the membership plan. They tack it on the end. They don't even have people sign it. And they say that's supposed to drive everything. On that minor agreement that they tacked on that's not of record, that most of the plaintiffs here undisputably never signed, that is supposed to deprive everyone here of their right to trial by jury and right to access to the courts. And respectfully, that's what the case is about. What can a developer impose on people just by sake of accepting a deed?
Well, in light of that, you heard the question that I posed to Ms. Austin earlier with regard to the community charter and the language that suggested that a claimant shall be entitled to file suit or initiate administrative proceedings if, if mediation, 30 days after mediation or something to that effect. How does that fold into what you were just articulating?
As follows. The community charter, by its own terms, supersedes any of the lesser documents. It is the Constitution.
And of course, she argued the contrary point, right?
Yeah, right. She says, well, specificity controls. But what we have here is just flatly inconsistent. The Constitution, the community charter says you can file in any court. That's what it says. And it says, in the event of conflict, the Constitution, win. And in my view, that is what they said and that's what they meant. What they can't do, in my view, and in my client's view, is give you that right in the Constitution and then take it away later on and maybe not even assign the document. It's not even a record. When you sit down at that closing table and accept your deed, you might be able to look up the community charter, right? Because it's of record. But what you cannot look up is what they're relying on. It is not filed in the Register of Deeds. They do it later, and they purport to maintain the right to change it at any time without notice, and they do.
But that's not in the arbitration agreement, right? That unilateral amendment is later, and under prima paint, we can only look inside the four corners of the arbitration clause, right?
No, I respectfully disagree with that characterization of prima paint. I understand the point. I
mean, that's sort of like the back, well, anyway.
Right, the container clause, I understand the analysis, but what you can look at is in the arbitration clause, how does that get amended? And now we've gone to the document they've tacked on. Mm-hmm. How does that get amended? Well, you have to refer to that companion clause that is in the container contract, and that's how they do. They can amend it at any time, and I don't think they disagree with that. I think they say we can amend it at any time with or without notice, and then we can change it back again. I don't think that's in dispute that that's what they say, but for purpose of the analysis, You can look, we've challenged the arbitration clause, which is for a court to decide under Simpson and the statute and so on. And how do they amend it? You can look to that companion clause as to how they purport they can amend that.
Back to estoppel, in your complaint, you seem to concede that you're receiving a number of benefits. So for the non-signatories, why would they not be stopped from arguing that they did not sign the agreement?
A number of reasons, and the threshold issue is there a signed arbitration agreement? And I'll move past that because, but I mean, the analysis in all the cases is that the court decides, did they sign an agreement? And if they didn't, there are some rarefied ways they can try to pull people in, but it's the exception. And here, what we have is the developer has essentially tried to say, well, these other people use the club, and therefore they gave up their right to trial by jury. And
No, I'm talking about the benefits that you receive as
I see as members of the community.
Yes. The direct benefits that you receive.
And so the benefits being just the existence of the club, like just being there.
Whatever benefits you derive from property ownership in that neighborhood.
Right. So to frame the question for my answer, and I'm out of time. May I
That's
continue?
fine. You've been out of time for the last minute, so
All right,
please proceed. We're just trying to
Sure.
get as much out of this
So
as we can.
just to frame the question, and hopefully answer it. What we have here is, this is not the typical scenario where there's a club in a planned community and everyone's a member and it's a mutual benefit nonprofit. This is a separate for-profit LLC that's located next door on property that is owned by that club. So to frame the answer, I do need to make that important distinction. So do we benefit from it? Well, we benefited in the same way that, say there's a Gold's Gym next door. It's nice having a gym next door if you exercise, but if you don't, it may not be, and you shouldn't be obligated, as they purport to put on your deed here, to pay money to that for-profit entity for as long as you own property in Palmetto Bluff. So is there a benefit to having it in existence? Arguably, for some. But they haven't proven that it's a benefit to everyone, and they sure haven't proven that these folks have given up their right to trial by jury and access to the courts through just the mere existence of the developer's separate for-profit entity in which the developer has complete control, and the property owners, indisputably under the developer's terms, have no control whatsoever.
I think the argument on direct benefits estoppel, and it can probably be put much more articulately than this, but it would go along these lines. For those people, not the three who predate the magic date, but for those people and LLCs and entities who purchased after the magic date and who claim to be members of the Palmetto Bluff Club, they claim membership. They cannot claim membership and at the same time disavow the arbitration agreement in that membership agreement. And now your answer to that may well be, or I take it your answer goes something along the lines of, that's too narrow a framing of this case. Really the appropriate framing of this case is that it's about this broader regime foisted on the members of this development by this for-profit entity. So don't look at it that narrowly. Take a broader view and look at it in terms of the requirement that they become members by acceptance of the deed and the all of the different ways the agreement is out of balance. You can put it much better than me, but I think that's kind of where what the dispute is, right, or the different framings, right?
I'm going to sign on to what you said, which is correct, the second part,
Okay.
and add one thing to it.
Okay.
And this is an important distinction, I think, that gets lost. But it's an easy thing to get lost because of the way the developer has kind of structured this. They're not members. Let me be real clear on that. The property owners are not members of this club. Now, they're called members. It's a membership. It says membership.
Yeah, they have a
on it.
revocable license.
Right. You know who the members are? The owners of the LLC, and that's what, so the better way to phrase this, if we're doing the analysis, is if you are granted a revocable license, so we should honestly take the membership idea out of it because it muddies up, in my view, the analysis. If someone sometimes is allowed to use a for-profit business, a revocable license on it, have they per se given up their right to trial by jury and so on, even if they never signed on it? And let's be honest, if it was given up automatically, why would they have people signing the membership agreements? They would only have that, they're only doing that because they know they need to. If you're signing on to the community charter and that's giving up, they need to have wording on the community charter. By buying this property, you may be giving up your right to trial by jury, but they don't do that. That's why they're having people sign it, and that's why when we filed the lawsuit, they started scrambling to find the signatures. They realized they hadn't been doing it. And now they're trying to get this court to save them.
You've not spoken, at least perhaps I've missed it, but you've not spoken about unconscionability and with regard to the elimination of the potential for treble damages. And I would imagine that would be a strong argument for you?
It is a strong argument for me, thank you.
Or is it so strong that it need not be argued?
It's so strong that it carries the day on its own. But you're right. I mean, there are a number of unconscionable points, and the idea of the unfair trade practices remedies being precluded is clear under Simpson v. MSA Myrtle Beach. You can't do that. So too with the 60-day statute of limitations they try to put on us. There's a separate statute that invalidates that. There are other problems with it. It lacks the language, the conspicuous notice that South Carolina law requires. It allows one party, we talked about this, to unilaterally amend it at any time in their view. It allows one party, the drafter, to ignore it and file suit in any court, and there's evidence in the record that they sue people all the time in court, but they say the property owners can't because you gave up your right to trial by jury when you bought property. And a number of unconscionable reasons. So, and I get the counter argument from Ms. Austin, well, just sever it. Just save us, Judge. You know, we tried to stuff this stuff in here. Just write it out. But I would refer this court respectfully to the Myrtle Beach case, and I think it's footnote 9, where our Supreme Court talks about how you should not try to save bad actors. And that's particularly when they stuff multiple terms in there. I think if you look at the cases about severing, sometimes there might be one term is problematic, but here we've got multiple. And in footnote 9 of Simpson, you know, the court says, first, when there are multiple ones, we're not going to rewrite that. Second, there's no severability clause here anyway, so a court would have to read in a severability clause in order to read out the bad parts, at which point they're redrafting the contract. And the third is that I would respectfully agree with South Carolina Supreme Court. The court should not be in the business of saving bad actors, where they'll sit in rooms and say, let's stop, like in Lennar, and say, you know, let's stuff this full of things, and then we'll just try to get it severed if any of them are bad. We'll make them go through all this judicial process, and we'll just get it severed. They're the drafter. They're the bad actor. I would respectfully submit the court should not save them by rewriting their contract.
Let me ask.
Okay, go ahead.
Your colleague argued that the folks who are buying into Palmetto Bluff are so sophisticated that they have to understand all of these things when they sign that deed, that they're going to be bound by all of these documents. They understand what the documents mean, and that literally just the deed alone is the thing that binds them to all of this. What is your response to that?
A couple things. I'd start with our Supreme Court's recent case of D'Amico v. Lennar, where it talks about sophistication of buyers. And I'm going to get to the second point, but in that case, what our Supreme Court explained was developers are selling hundreds, if not thousands, of pieces of property over the course. Even the most sophisticated buyer will buy a handful of properties. And I would respectfully submit, if we look at the covenants in this, which are written by the developer, I mean, even trained, experienced lawyers would be hard-pressed to wade through that. It is what the point in the case law is the relative disparity, the relative sophistication, not if someone went to college versus they get one standard versus someone who may not have graduated high school. The courts aren't in the business, respectfully, of looking at the people and then deciding what law applies to them. The court says, look at the relative disparity and sophistication. And here you have someone who may have a degree versus a developer who is in the business of selling this and drafting these documents. So what the analysis, in my view, is whether this is, in the court's view, I believe, is this a contract of adhesion? And that's, I think, where the sophistication element comes in largely. And this is indisputably a contract of adhesion. You take a deed, you apparently have signed on to this, it's not negotiable. I don't think it's disputed that it's negotiable, it's not.
But
So
even if it is, all adhesion contracts are not necessarily unenforceable. I mean, so what's the next point that you're gonna make after it's an adhesion contract?
exactly,
I mean, 'cause
unconscionability.
that's not bingo. you
Fair,
know?
it's not bingo, but I was groping towards the sophistication idea, but I go to the adhesion contract, yes, check. I move on to the next point, which is Your Honor's question about is it unconscionable or not, and I've mentioned that, all the points that are wrong with it, so.
May I ask, your friend mentioned the Henry Schein case and Rent-A-Center for unconscionability, not going to contract formation. Just any thoughts on those, or would you add another case to my reading list? I'm happy to take one if you have one you want to add.
I think contract formation under D'Amico.
Okay.
Contract formation, is there a contract formed, is a matter for the courts to decide. If we read the recent Supreme Court case in South Carolina.
No doubt about that. And unconscionability going to, I guess, D'Amico, I'm embarrassed to say I sat on that case, but I don't remember everything about it.
Yeah,
But
I would also look to the recent Lennar case by the South Carolina Supreme Court, where it talks about developers and how they don't get rewarded for bad acts
Yeah.
and so on. So those on unconscionability would be
Okay.
my go-to cases. And the thing about the unconscionability is each of those points, the statute of limitations versus Unfair Trade Practices Act violations and so on, the lack of conspicuous language, each of those has its own body of law. Respectfully, this clause has so many problems with it that I just don't think it can be saved.
thank you.
Thank you, Mr.
Thank you.
Ford. Ms. Austin?
Thank you, Your Honors. May it please the court. Parties are responsible for the agreements that they sign. They're responsible for reading the agreements that they sign. The charter here specifically states that upon becoming an owner in Palmetto Bluff, you become a member of the club. The club amenities are by no means an overlooked minor aspect here. People join Palmetto Bluff because it has this club and all of these amenities. The community charter, which is recorded, specifically says that upon becoming an owner, you will be a member of the club subject to the club documents. The club documents include the membership plan, which contains a binding arbitration agreement, and contains membership agreements, which are signed individually by each of these owners. The relevant agreement of the club documents, which contain the arbitration agreements, are signed by the owners upon taking title. And on the first page of those membership agreements, it states that the claims are subject to arbitration. This case involves the rental of real estate.
That's what I was going to ask you. Is this a dispute about the rental of real estate, or is it about contracts underlying the sale of real estate?
It is about the rental of real estate, Your Honor. If you go a centimeter deep in the complaint, everything here revolves around the club. There are 16 causes of action. The club is a defendant to every single one. Every single cause of action contains and depends upon claims involving the club. Just as some of the remedies that they seek damages for dues and fees they have paid. They seek ownership in the club. They seek, they have claims for breach of the club documents. The club is at the heart of this dispute. The membership plan containing the arbitration agreement is attached to the complaint. Also attached to the complaint is demand letters, which predated the mediation leading to the filing of this lawsuit, which make it very clear that this is about the impact that they think that limited access to club amenities has on their ability to market their properties to short-term renters. Their short-term renters, not only are at least 8 of the plaintiffs, it is undisputed, are from out of state, but it is also undisputed that the owners here, they market their properties for rent on nationwide platforms to a nationwide audience on platforms like VRBO and Airbnb.
Can you give me a principle of law that tells us we should look at that sort of outside of the written agreement information in determining whether a dispute is governed by the Federal Arbitration Act as opposed to the State Act? Because it kind of looks like the contract with the arbitration clause is just a membership in a private club in South Carolina. It seems about as in-state as it gets.
I believe that it's determined from the face of the complaint based on what their claims are.
The face of the complaint determines whether an arbitration clause, federal or state law applies?
I misspoke. I'm not saying that it's limited to the face of the complaint, but I'm saying that here that can be determined from the face of the complaint, because these are claims that are brought by plaintiffs that are bringing them as a class, as a purported short-term renter class. They do not distinguish in any way amongst the commonality of those plaintiffs. It's alleged in the complaint that every single one of the plaintiffs owns property in the designated rental area. Again, they attach the demand letters, which specifically make it very clear that this is about short-term renter rights and the marketability of their property.
Well, doesn't the arbitration provision itself say that South Carolina law will apply? I'm just confused because there's a lot of discussion about whether the federal arbitration provision should apply or whether South Carolina provision should apply, but it seems to me that the arbitration provision itself says South Carolina law will apply in this arbitration.
The arbitration provision provides that the governing rules will be the American Arbitration Association commercial arbitration rules, and that it will be subject to the FAA. To the extent that there are state law claims, South Carolina law applies to those claims.
So we just ignore the South Carolina Uniform Arbitration Act? Because that's a state law too.
Correct, Your Honor. The South Carolina Uniform Arbitration Act has been complied with, but it's been displaced by the incorporation of the uniform of the American Arbitration Association commercial arbitration rules.
It's been, I'm sorry, what was the verb you used?
Displaced by.
How so?
Because by incorporating the American Arbitration Association uniform commercial arbitration rules, that specifically delegates the case to the FAA, to the Federal Arbitration Act. Again, to the extent that there are South Carolina claims, then South Carolina law applies. But really, the Federal Arbitration Act and the South Carolina Uniform Arbitration Act are not, they're not inconsistent here. But by incorporating the Rule 7 of the Commercial Arbitration Act, the Federal Arbitration Act applies. Here, the relevant question is whether or not it involves interstate commerce. Here, it clearly does. The rental of real estate to buy out-of-state plaintiffs to out-of-state and nationwide renters undoubtedly involves interstate commerce. It has been determined that while the sale of property might not involve interstate commerce, indisputably the rental of real estate does. And that's what this case is about.
But the issue of, the first issue to reach, that is the enforceability, or not the enforceability, but the existence of the contract, that really is not the existence of a contract as it relates to the rental of property or the rules of the community or of the club. That really has to do about whether there is an existence of a contract that arises from the sale of the property, which is a South Carolina event. Is that correct?
The sale of the property, which again is marketed to nationwide clients, and many of the plaintiffs here are from out of state, but the sale of the contract is not what is at issue in this lawsuit. The plaintiffs are not complaining about their purchase of the property. They're not seeking to undo their purchase of the property. What they're complaining of is the fact that they joined the club, that they've had to pay fees and dues, and that they don't have more access to the club, and that their renters don't have more access to the club.
It seems to me they're saying they were forced to join the club, that they had no choice about that, and that's the issue.
They do claim that they were forced to join the club, and they bring this lawsuit as owners and members, but they cannot bring their claims on the basis that they are owners and members, but then disclaim the membership documents which specifically govern the club, which is what they seek to do here. They seek to have it both ways. It's undisputed that the plaintiffs are all members of the club, and they cannot both bring claims on that basis and have standing for that basis, but then say, but we're not subject to any of the agreements that govern the club and ones that we specifically signed. And if I may, I did want to point out, going back to something earlier, that that the 3 was not a misstatement. Here, it's undisputed. The plaintiffs acknowledge and the circuit court acknowledge that there are undeniably signed membership agreements containing arbitration agreements between the club and 7 of the plaintiffs. It is also undisputed that there are 9 membership agreements which contain mandatory arbitration agreements that contain the addresses of the LLCs that are signed by their principals or members. That can be determined from the face of the documents themselves, from the face of the complaint and from the documents themselves.
The 3 is before the magic date, right?
The 3 is, correct, Your Honor, the 3 is before the magic date. The 3 is also, that is the only number of defendants that do not have either an expressly, directly signed contract or a contract containing an arbitration agreement that is binding upon them by operation of agency or assignment principles, or that don't have another, as to a few outlier plaintiffs, that do not have another binding arbitration agreement, such as in their purchase and sale agreement. There are only 3 plaintiffs that do not have any signed arbitration agreement that would arguably govern this dispute. And they are the ones that predate the 2017 date.
Thank you.
Thank you, Your Honors.
Thank you both for your impassioned and intense and informed arguments. We'll be in recess.
Be upstanding for the court.
Oh, excuse me.